Hayden. Bill. Alan. Well, the file that's at the top of the list isn't at the top of the stack. You know what happened to it, Hayden?
Indy Allen.
Yeah. Well, would you go look in my,
Yeah, let me check that.
okay, Shannon, put us on. Hayden versus Allen.
William Rapley appearing on behalf of Jennifer Hayden, Your Honor.
Senator Ken Hotchkiss
And is-
appearing on behalf of David Allen.
Mr. Allen is present, but I didn't see Ms. Hayden. I've got a phone in the waiting room that I can't identify. Are you expecting your client, Mr.
Yes, Your
Rapley?
Honor. Yes, Your Honor.
All right, let's see if she's on this Galaxy. Is that her?
Yes.
Okay, I don't know whose motion this is. For some reason, the file isn't on the stack, so I'm sure you guys know.
Your Honor, if I could just speak to that real quick. Actually, is what occurred procedurally in this case is Ms. Hayden had filed a motion in, I think, May 17th. She filed it in pro per. My client was never served with a copy of the motion. And he then filed his own motion sometime later. We had noticed this case up in front of Judge Rapley, who was assigned to the case. And on that date, we had discovered that Judge Rapley had a conflict. And we also discovered that mom had filed her own motion, but my client had never been served with it. So we really have kind of competing motions that essentially are asking the same thing. So I'll leave it to the court's discretion as to who you'd like to go first. Perhaps Mr. Rapley could lay out his client's case first, in that she filed the motion prior to us.
All right, and Shannon, both Ms. Hayden and Mr. Allen are present.
Yes.
Go ahead, Mr. Rapley.
Your Honor, the current order provides that Jennifer Hayden have sole physical custody of this child. The parties had, without a benefit of court order, had worked out a parenting time schedule. In May of this year, May 17th, after or during a weekend visit with the father, he decided to keep the child and kept the child until just recently. In fact, we were before the court. Our motion was set about 2 weeks ago. Counsel and I decided that we would communicate with you on Wednesday before the motion hearing. We did that via Zoom. There was an agreement with you that the child would be returned and we would submit an order. Well, it took a day or so to get the child back. An order was prepared and sent, and the next weekend visit with dad, he's kept the child again. So we're asking that the status quo be reinstated, but that because of dad's behavior, that his parenting time be every other weekend, and holidays per the front of the court handbook. This is the second time that my clients had to get me involved in trying to get her child back when there's a court order that gives her full custody of this child. And we were here before. We thought we had it worked out. We submitted an order and we're right back where we were. So I'm asking, in addition to that order, that the court order an award of attorney fees for us having to do this. The order is clear. My client has primary custody of this child. Dad has what they call reasonable rights, not even reasonable rights, is it's agree between the parties. And my client doesn't agree that he keep this child. In addition to that, Judge, I don't know what he's up to, but my client received information that he's attempting to enroll the child in a school that's not consistent with her prior schooling. He doesn't have any authority to do that.
Mr. Hotchkiss?
Your Honor, my screen had locked up at the last part of Mr. Rapley's argument, but let me just begin by saying it is true that the parties have joint legal custody. The parenting time provision in the most recent order, which is back from 2012, says that my client will have flexible parenting time. For the last several years, what the parties had done was they worked out an agreement where my client had every single weekend from Friday to Sunday, and on many weekends from actually Thursday to Sunday. And so he's been having at least 8 overnights per month. Now, what had started earlier this year is that my client's daughter, Addison, who's 12 years of age, had become increasingly uncomfortable at mom's house. And from what I understand, she attributes a lot of this to mom's then boyfriend, now I guess new husband, who is making her extremely uncomfortable. She has indicated that the new husband or mom has told her to sit on the new husband's lap and call him daddy. She's indicated that if she's in the bathroom with the door locked, that taking a shower or bath or something, that he'll knock on the door and she'll have to kind of be behind the shower curtain, if you will, while he's in the bathroom. She finds that to be extremely uncomfortable.
Excuse me. Am I allowed to speak during this?
No, you need to be quiet. That's why I muted your microphone.
Okay, and Your Honor, and so my client has done what he can do to insist that Addison go to mom's house. It is Addison, frankly, who is absolutely refusing to go. And Mr. Rapley's right. We came before Your Honor and said, look, we have this situation. We recommended that the court appoint a guardian ad litem. The court agreed that was actually going to be part of our consent order that we entered into. Mr. Kelly obviously didn't have even time to get involved. My client did everything possible to have Addison go over to her mother's house. However, when she gets there, for the first half hour to an hour, she describes an event where she's forced to sit down, and mom and her new husband take turns yelling at her. And she's indicated that mom's new husband was nose to nose with her with a clenched fist. And so she became fearful of him. She says that she's extremely uncomfortable over at the house, and it would literally take physical force for my client to deliver Addison to her mother's house, to the extent that he would probably be facing domestic violence kinds of issues. So that is really where we're at with this. I think there's a need here for counseling or an independent source in addition to Mike Kelly, where Addison is free to talk about the different things that go on there. You know, we put Addison at risk because in order to come in here and ask the court for certain things, we have to disclose what Addison has said. And that puts her at risk because she goes back to mom's, and then of course she pays the price like she did last time. So we're asking that the court essentially deny the motion, let Mike Kelly get involved, and let's get a therapist involved so we can ascertain what's going on in the house. I can tell you that the issue with respect to school is absolutely untrue, according to my client. They've never attempted to enroll her in another school or anything of that nature. Clearly, they have legal custody. It's also clear by statute that both parties are entitled to a specified parenting schedule. And that was going to be the purpose of an evidentiary hearing down the road, but immediate concern is Addison's absolute refusal to go. Thank you.
So, Mr. Rapley, your client is obviously quite upset. Would you like to speak with her in a private waiting room and find out what it
Yes.
is she wants to communicate to the court? All right,
Yes.
I'll put you in a breakout room.
Your Honor, I got an invitation to a breakout room as well. I assume maybe that's an error. I'm unable to hear you if you can hear me, Judge. I'm unable to hear anything, Your Honor. Can you hear me, Your Honor?
I can, yes.
Okay, thank you. I was unable to hear you there for a minute.
Yeah, my Zoom is acting up today and it ended up putting me in the breakout room.
Oh, okay.
And I looked, okay, here's Mr. Rapley. All right, let's try it again.
Get me out of my space.
Uh, I'm gonna let you talk to your client. I'm gonna put every one of you back in the waiting room and I'm gonna call the next case.
Thank you, Your Honor.
True gem of Ashland.
All right, let's try again. Mr. Brown, can you hear me?
Yes.
And we've got Hannah Smeltzer. Are you expecting anyone else for the hearing?
No.
Okay, so we're here for an emancipation hearing. Ms. Smeltzer, can you hear me?
Yes.
All right, well, I guess we can take a little testimony, Mr. Brown. Ms. Smeltzer, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear to tell the whole truth, nothing but the truth, to the right hand of God. I think I
Thank
said
you.
that right.
Go ahead. State your full name, please.
Hannah Marie Smeltzer.
And Hannah, how old are you?
I'm 16 years old.
Go ahead, Mr. Brown.
Yes. Ms. Smeltzer, when you filed this petition, you were just under 16 years old, correct?
Yes.
And since that time, you have turned 16 years old as the date of this hearing. Is that correct?
Yes.
You do not live with either of your parents, correct?
Yep.
Does your father reside in New Carlisle, Indiana?
Yes.
And you have very little interaction with him. Is that a fair statement?
Mm-hmm.
You have to say yes or no. Uh-huh, and
I'm sorry. Yes.
And your mother lives here in Jackson. Do you see her quite often?
No.
Okay. Have you informed your parents that you have filed a request to be emancipated?
Yes.
Do they object to you being emancipated?
No.
And in fact, you asked them to write letters on your behalf, and they indicated that they would do so. Is that a fair statement?
Yes.
However, they never got around to doing it, although you asked them numerous times. Is that fair?
Yes.
Hannah, where do you live?
I live on 915 West Michigan Ave, apartment B.
Okay, and who do you live there with?
I have a roommate that recently just moved in.
Okay, but prior to that, you did not have a roommate,
No.
and you secured that apartment all on your own with the assistance of your brother who signed for you.
Yes.
You are employed where?
At Jet's Pizza.
Okay, and what do you do at Jet's Pizza?
I pretty much do everything besides deliver pizzas.
Okay, how long have you been employed there?
Since January.
How much do you make an hour?
I recently just got another raise, so I'm pretty sure I make between $11.75 and $12.
And how many hours a week do you work?
About 30 to 40.
And do you also go to school?
Yes.
And where do you go to school at?
SCMV. It's online.
And what grade are you in?
I'm in 11th.
Okay, are you on track to graduate through your current program?
Yes.
Have you recently, you do not have your driver's license, do you?
No.
However, you recently bought a 2004 Chevy Malibu in contemplation of you receiving your license, so you will have a car when you do obtain your license, correct?
Yes.
Hannah, I see that a medical professional at your school or Jackson High wrote a letter or a statement on your behalf. Is that correct?
Yes.
And in it, she indicates that your parents are not reliable to take care of you. Is that a fair statement?
Yeah.
Do you feel as though you make enough money now to care for yourself and provide for yourself if the court grants your emancipation?
Yes.
You realize that if he grants this, you will be treated as though you were an adult, meaning you can be sued or you can enter into contracts as if you were an adult above the age of 18. Do you realize that?
Yes.
You think you can handle that?
Yes.
Thank you, Judge. I would have nothing further.
So Hannah, according to the affidavit that was submitted with your petition, it appears that both of your parents have drug addiction issues and are not fit to care for you and are actually a hazard to your well-being. Do you agree with that?
Somewhat.
What's your hesitation?
I agree with it on my mom's end, but my dad, he doesn't really do drugs anymore. It's the people around him.
Has your father been involved in your life?
Not as much as he should have been.
I see he lives in Indiana. I mean, how often do you see him?
Usually maybe 3 or 4 times out of the year.
And you've been living in this apartment for how long?
Since the April.
You haven't had any trouble making the rent payment?
No.
All right, well, I am satisfied based upon the testimony that emancipation would indeed be in your best interest, and I will order that. We will need to get an order prepared. I don't have one in the file, but I'll get busy on that. And we'll let you know as soon as an order is entered. We should send that to well,
She did not receive her notice for this hearing, so that's that. I was getting ready to say that gives me a little concern. The only reason she's here is because I told her the date.
it says it was mailed to 915 West Michigan Avenue, Apartment B. Is that the correct address?
Yes.
And it was mailed on July 22nd. Oh, wait a minute. For some reason, they left her off the notice of hearing. But definitely it shows that both parents were notified. All right, well, that's why she didn't get it, because it didn't get mailed to her. We'll make sure it gets mailed this time. Okay, Hannah, did you have any questions for me?
About how long will it take?
It should go out today or tomorrow.
Okay, I appreciate it. Thank you so much.
You're welcome. Best of luck to you, Hannah. Thank you, Mr. Brown.
Thank you. See you soon. Good luck on your matter.
Okay, we are back on Hayden versus Allen. It appears that I've lost your client, Mr. Rapley. Did you get a chance to talk to her?
Yes, Your Honor.
Was there anything else you wanted to bring to my attention?
Absolutely. Judge, she's been involved with Corey, her current husband, for 3 years.
Just a second, Mr. Rapley. She just appeared. Let me get her in here before you. Okay, go ahead.
Your Honor, the relationship that she's had with her current husband has been going on for over almost 3 years. So
Well,
this
looks like
such
we've
as has
lost.
been made this morning. In fact, Judge, look at his motion. Nothing about this in his motion.
Mr. Rapley, we lost much of what you were doing. Your screen locked up. Could you start over?
Yeah, Your Honor, the relationship that my client has had with her current husband has been going on for just under 3 years. This isn't a new relationship. And if we look at the father's motion, which was filed over a month after he retained possession of the child, he doesn't mention any of this stuff. This is all new. And I suspect because of what he put in his motion that didn't work the last time, he's got to add things to this storyline in order to convince you to do something. There's nothing in here in this motion about any of this stuff. And he's so concerned about his daughter's safety, Judge, when he dropped her off, and we finally got her back, when she finally went home, her father dropped her off wearing a bra and a very small pair of shorts. That was it. How does a man who's concerned about the safety of a 12-year-old daughter like that drop her off at her mom's house? At this point, we're asking that the child be returned. And, you know, counsel, let me just add, Judge, that counsel's reference comments that the child has made. When the child finally got back to mom's house, she admitted that she had lied. Concerned that mom would not let her see her dad again. That was the discussion that was had when she walked into the house, after being gone for over 2 months.
What did she admit to lying about?
That she didn't want to be there with mom because that was dad's storyline. Here, that's the problem, is dad's had this child. He's manipulated her. And until there's some break from that, the storyline is going to continue.
Exactly.
I'm still not, ma'am, I'm going to mute her again. She can't seem to keep her mouth shut. So I'm still puzzled, Mr. Rapley. She admitted to mom that she lied to dad about not wanting to go back to mom's house?
No,
what was the lie?
The lie was that she didn't want to go back to mom's house. At some point, the police were involved. My client spent 2 months trying to get her child back. She went to the front of the court. They wouldn't do anything because it's not a specific schedule. The police couldn't do anything because the child wouldn't come out of the house. And they told my client that unless she's out of the house, they can't do anything about it.
we have the police report to falsify that.
Be quiet.
Sorry.
How long has this custody order been in place?
12 years.
Well, it's been in place, Your Honor, since July of 2012.
And I'm at a loss because I don't have the file. Have there been a lot of custody motions
0.
over the years?
0.
It just seems really unusual that I get, after 12 years of whatever the arrangement has been, that things are getting out of control so quickly. I'd really like to be able to get to the bottom of this. So I'm hearing two completely conflicting stories as to what's going on.
I believe there was a support review recently, Judge.
And this doesn't have anything to do with child support. I think one of the things, Mr. Rapley's point, is that Addison continues to disclose information, which is why some of the information was not contained in my client's original motion, which is also a good reason to have a counselor and or therapist involved. I was hoping that Mike Kelly could maybe interview Addison, give the court maybe a preliminary report on what he thinks after interviewing her. The issue with respect to dropping her off in her bra and underwear, or whatever mom said, is those are the clothes that mom bought for her. My client didn't buy those clothes for her. And so, it's just an attempt to twist that which is going on. I don't understand, I don't know what the court would have my client do when Addison is so adamant that she will not go. I think you need a third party involved to try to get to the bottom of it with her.
So so far, Mr. Kelly, there hasn't even been an order appointing an LGAL, correct?
That's correct, Judge. That was part of the decision that we came to when we met with Your Honor before. However, an order never entered subsequent to that, but that was the full intention. But he's not been even appointed yet, technically.
And the child doesn't have a therapist currently.
Correct.
So right now, there's no independent third party that can give me a read on where this child is actually coming from.
That is true, Judge.
I would really like to hear that before I do anything. If what Dad's saying is true, of course she would admit to lying to avoid being subjected to what I'm told she was subjected to the last time she was returned. And I don't know. I don't know what's true here. If the child is that distraught, there must be a reason for it. What is the reason?
I don't think, we're not saying she's distraught, Judge. I mean.
Well, I get that, Mr. Rapley, but I'm hearing that she is distraught, and obviously I'm hearing two different stories.
Well, Judge, she was with her mom for about a week between the time he dropped her off after we were in court the last time. And he didn't have to go over there and pick her up. We didn't get any phone calls that this child is calling Dad in distress. Nothing until he got his normal weekend again, and he doesn't return her.
Well, part of that, Your Honor, frankly, is I think there are some text messages back and forth between Addison and her father. And I think, in fact, she was encouraged to try to stay. It is Addison who is adamant that she doesn't want to. And I'll be straight up with everyone. And that is, I told my client, look, we have to follow what the court had indicated it may do, and let's try the parenting time. Addison returned home to dad and says, I'm not going back. And so that's why we are here where we are, kind of at this stalemate. We definitely need a third party.
All right, well, I want the LGAL appointed immediately. Whatever other order needs to be done, the LGAL needs to be appointed immediately. Mr. Kelly needs to be apprised of the urgency. I'd like him, before he does a full report, to at least interview the child and find out what's going on here. Is it truly the child that's doing this? Or is it dad somehow pulling the strings behind the scene, which is what mom thinks is happening? But if when I've got a 12-year-old who's, if it's true, refusing to go to a parent's house, there's got to be something going on. If that's true, I want to get to the bottom of it. I'm going to prepare the order appointing Mr. Kelly. I'm going to communicate to him that I want him to interview the child at his earliest convenience and report back to the court, as well as a copy to you, which will be at least initially less than his normal thorough job of interviewing everybody. But I want him to at least talk to the child before I do anything. So I think that's the safest course of action. I want to get to the bottom of it. If I find out that it's dad that's manipulating things, there'll be repercussions. We'll get that order prepared and issued. We'll probably get it out today. I'll get it to Mr. Kelly. We'll copy you on the communication council so you both know what's going on, and have him report back to me. I'm hoping he's able to do that within the week, so that I can make some kind of an interim decision. I'm not ordering anything else today.
Thank you, Your Honor.
So the order's in effect. Well, I mean, I'm not sure what we're doing going forward.
The order that, well, what's happening going forward is I'm appointing an LGAL. I'm asking him to report back to me immediately. And once I hear back from him immediately, I'll make a further order as to what's going to happen with parenting time.
So the current order stays in effect until you change it?
I am not issuing any order today other than what I just told you, Mr. Rapley. That concludes our hearing.
Thank you.